there is a letter, one page, folded into a standard business envelope, mailed from the post office on a Tuesday afternoon, and once it arrives, the calls stop, legally, immediately, no negotiation, no pleading, and no hoping the collector suddenly grows a conscience. The law itself intervenes. Most Americans have never heard of this letter. They assume the ringtone, the voicemails, the letters with red ink are permanent, something they have to endure until they pay or until they give up and file for bankruptcy. That assumption is false. The letter exists. It costs the price of a stamp, and it converts a terrified consumer into a plaintiff with a federal case. This is not life advice. This is an investigation into a statute. The Fair Debt Collection Practices Act, enacted in 1977, effective the following year, a piece of legislation designed to eliminate abusive, deceptive, and unfair practices by third-party debt collectors. Tucked inside this statute are two written instruments that operate like deadbolts. The first is called a debt validation request. The second is a cease-and-desist letter. Neither one cancels the underlying debt. That is not their job. Their job is to halt the harassment, freeze the clock, and shift the balance of power. And the most important piece of evidence in this entire case file is not the letter itself. It is the little green card that comes back from the post office, the certified mail receipt, the return receipt, the thing you signed for. Because without that receipt, you have no proof the letter was ever delivered. Without proof, you have no case. Without a case, you have no leverage. The receipt is the physical key that turns a paper request into a federal claim. Open the case. The first contact arrives. A debt collector calls. Then another. Then a letter in the mail, often generic, often vaguely threatening. Under the FDCPA, that initial communication triggers a duty. The collector must send you a written notice containing the amount of the debt, the name of the creditor, and a statement informing you that you have 30 days to dispute the debt in writing. That language is buried in the fine print. Most people skim past it. They do not realize it is a timer, a fuse, a 30-day window that gives them a right they never knew existed. If you send a written request for validation within that window, the entire collection machine must grind to a halt. Not a pause for a few hours, not a polite request, a legally mandated stop. All collection activity must cease. No calls, no letters, no credit reporting without noting dispute. The statute is 15 U.S.C. section 1692 G, and it reads like a command. Once the consumer disputes the debt in writing, the debt collector shall cease collection of the debt or any disputed portion thereof until the debt collector obtains verification of the debt and a copy of such verification is mailed to the consumer. The word shall is the most powerful word in administrative law. It does not mean maybe. It does not mean if the collector feels like it. It means the collector is legally obligated to stop. The phone goes silent. The mailbox empties. The collection clock freezes, all because of a letter. But the details in that statute are forensic, and if you ignore one of them, the protection evaporates. The dispute must be in writing. An oral dispute, no matter how emphatic, does not trigger the halt. You can scream into the phone for an hour about a debt you never heard of. It means nothing under the statute. The collector can note it and keep calling. The request must be mailed within 30 days of receiving the initial validation notice. Not 30 days from the phone call. Not 30 days from when you finally open the letter. The clock starts when the notice is received. If the envelope sits on your kitchen table for 2 weeks, you have already burned through half your ammunition. Miss that deadline and the automatic cease collection provision disappears. The collector can continue calling. We can still dispute, but the leverage is gone. The law still protects you against certain abuses, but the emergency brake no longer applies. And there is another catch. A trap that catches consumers who draft the letter in good faith. The letter must be sent in a way that proves the collector received it. This is where the certified mail receipt becomes more than a formality. It becomes evidence. first-class stamp provides no tracking, no proof of delivery, no date stamp. The collector can say they never got it. The court will ask you to produce evidence of mailing. If you cannot, the validation request is treated as if it never happened. Every consumer protection attorney will tell you the same thing. Use certified mail. Request a return receipt. Keep the green card in a file. That card is a sworn statement from the United States Postal Service that a specific piece of mail was delivered on a specific date. It is the document that stops the collector from claiming ignorance. It is Exhibit A in any later case. What does the collector have to do once they receive the validation request? They must obtain verification of the debt and mail it to you. The statute does not define verification exhaustively, but courts have consistently required something that shows the debt is yours and the amount is accurate. A computer printout from the collector's own database is often not enough. That minimum verification should include a copy of the original contract, the final account statement from the original creditor, or some record that links you to the obligation. Without that, the collector cannot resume collection. They cannot call. They cannot sue. They cannot report the debt to a credit bureau without also disclosing that it is disputed. The pause is indefinite until they comply. But some collectors ignore the letter. They bet that you do not know your rights. They gamble that you will not sue. When they do, they cross a line into a private enforcement provision. 15 U.S.C. Section 1692K, Civil Liability. If a debt collector violates the FDCPA, the consumer may recover actual damages, statutory damages up to $1,000 per lawsuit, plus reasonable attorney's fees and court costs. But that's $1,000 per lawsuit, not per call, not per violation, per lawsuit. But that $1,000 is not conditional on proving financial harm. It is statutory. It is awarded simply because the law was broken. And if you can show actual damages, emotional distress, lost wages, medical bills for anxiety, those are recoverable on top. Attorney's fees are mandatory if you prevail. That means a consumer lawyer may take the case on contingency. The collector pays the legal bill. The $1,000 goes to you. This is not a criminal offense. The FDCPA does not send collectors to jail. It imposes civil penalties, but a well-documented violation turns the collector into a defendant. Suddenly, the person who is being harassed is the one filing motions. Now the second letter. A different instrument entirely. The cease and desist. It is authorized by a separate section of the same statute, 15 U.S.C. Section 1692C, subsection C. The language is brutally simple. If a consumer notifies a debt collector in writing that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication, the debt collector shall not communicate further with the consumer. There are exactly two exceptions carved into the statute. The collector may send one final notice to inform the consumer that collection efforts are being terminated, or the collector may notify the consumer that the collector may invoke specified remedies. That means a lawsuit. So the cease and desist letter does not stop litigation, but it stops everything else. No phone calls, no text, no collection letters, no reminders of a debt you may or may not owe. The statute uses the same word again, shall. The obligation is mandatory. Once the collector receives the letter, every subsequent communication is a violation. Every ring of the phone is a violation. Every envelope is a violation. And every violation is a separate count that can be added to a civil complaint. The forensic requirements are identical to the validation request. It must be in writing. It must reference the statute. It must be sent certified mail with return receipt. The green card is the proof that activates the legal prohibition. Without it, the collector can claim the letter never arrived. With it, the collector is boxed in. The date on the receipt marks the moment the legal wall was erected. Any communication after that date is actionable. The receipt is irrefutable. It is not a copy. It is not a photograph. It is an original government document that proves time, place, and delivery. Judges accept it, collectors fear it, and most consumers never think to save it. There is a misconception that these letters erase the debt. They do not. They are procedural shields, not substantive swords. A validation request forces the collector to prove the debt exists. It does not extinguish the obligation. If the collector locates the original contract, the statements, the account history, they can mail it to you and resume collection. They can then file a lawsuit. If they obtain a judgment, they can garnish wages, levy bank accounts, place liens. The cease and desist letter blocks communication, but it does not block the courthouse steps. Some collectors, after receiving a cease and desist, immediately move to litigation. They interpret the letter as a declaration that negotiation is over. That is a risk the consumer must weigh. But for someone who cannot sleep because the phone rings at dawn, trading calls for a potential lawsuit may be worth it. And if the collector sues without proper verification, the consumer has a defense and a counterclaim. What about credit reporting? The FDCPA does not automatically delete a disputed debt from your credit file, but it does require the collector, when reporting the debt, to communicate that the debt is disputed. That notation can make a significant difference if a lender is reviewing your report. It signals that the validity of the amount or the obligation is legally contested. The credit bureaus may investigate, and if the collector cannot verify, the item may be removed. But that process is separate from the validation request itself. The letter is the trigger, not the conclusion. You need to draft the letter with forensic precision. A debt validation request should state, "I am writing in response to your initial communication dated. Pursuant to 15 U.S.C. Section 1692G, I hereby dispute this debt in its entirety and request verification. Please provide the name and address of the original creditor, a copy of the contract or instrument bearing my signature, and a full accounting of the amount claimed. Include the account number if you have it. Do not admit you owe anything. Do not offer a partial payment. Do not explain your hardship. This is not a negotiation. It is a legal demand. Sign it, date it, make a copy, put the original in an envelope, walk into the post office. As for certified mail, return receipt requested. Pay the fee, keep the receipt. When the green card returns, clip it to your copy of the letter. That bundle is now a legal instrument. It should be stored in a file folder labeled with the date and the collector's name. That folder is your case file. A cease and desist letter is even shorter. Reference 15 U.S.C. Section 1692C, subsection 1692C, subsection C. State, I refuse to pay this debt. Or I wish you to cease all further communication with me and with any third parties except as permitted by law. Do not ramble. Do not threaten. Do not cite penalties. That is the law's job. The collector either knows the law or they do not. Either way, the letter is your notice. The certified mail receipt is your evidence. The file is your case. Once the letters are sent, you must document everything. Every new call, log the date, time, caller's name, and a brief summary. Save every voicemail. Do not delete them. Print every email. If a collector leaves a message after receipt of the cease and desist, that voicemail is a violation. If a collection letter arrives 2 weeks after the validation request without any verification enclosed, that is a violation. Each piece of paper, each digital file, is another entry in the case file. The file is not just a record. It is the foundation of a potential lawsuit. Without documentation, you have no case. With it, the collector faces a paper trail that leads directly to a federal claim. The statute has been on the books for over 45 years. Most Americans have never read it. Collectors rely on that ignorance. They rely on the stress, the fear, the shame. But the FDCPA was written to give consumers control. The validation request is a pause button inscribed in federal law. The cease and desist is a permanent mute switch, and the certified mail receipt is the piece of paper that binds them together. It is the object that turns a letter into a legal event. Most people throw it away. They treat it like a junk mail receipt. They should frame it because that small green card is the evidence that stops the collector from saying the words, "We never received the thing." It is the document that opens the door to statutory damages, attorney's fees, and a federal case. It is the quiet object that most Americans never know to keep. You are not powerless. The law gave you instruments, 2 letters, 1 receipt, a file that grows every time the collector ignores the statute. The case is yours to build. The evidence is already in your hands.